Hey, I'd like to welcome everyone to this meeting. It's a planning meeting, and please note that this meeting is being broadcast and recorded. Recordings will be made available on the town's YouTube channel. Thank you. We acknowledge that this land on which we are gathered today is part of the ancestral land of the Chippewa, Ottawa, and Potawatomi peoples, referred to collectively as the Anishinaabe. It is through the connection of the Anishinaabe with the spirit of the land, water, and air that we recognize their unique cultures, traditions, and values. Together as treaty people, we have a shared responsibility to act with respect for the environment that sustains all life, protecting the future for those generations to come. I would like to remind anybody that if they have a declaration of pecuniary interest, please declare it at the appropriate time. And now I'm going to pass this over to the mayor who just walked in. So
That was quick.
thank you, Mr. Mayor, for coming.
You're welcome.
Warwick. We both ended up at the same meeting.
Okay, I just.
Where would that be? Oh, okay. Councilor Basie, I was on municipal business.
Yeah, I used that one last time.
Okay, so now we're on item number 4.1. Have we done that?
No, haven't done.
Okay. Is there any delegations this evening? None? All right. Business rising from the previous minutes. Anything under that, Ms. Flynn?
Bansky, were you going to bring it up?
Thank you. So earlier today, we were informed that the appeal of OPA 51 and 54, which is directly in regards to surplus farm dwellings, has been withdrawn. Notice of withdrawal has been provided to OLT. OLT will still need to confirm the withdrawal, so there will be a bit of a week or two of waiting for the final withdrawal. In the meantime, staff will be publishing guidance documents for farmers looking to have surplus farms dwelling and will dwellings severed. And we will look to also start hosting those applicants to help guide them through the process. So although we're not formally accepting applications shortly, we will be starting to provide information on those surplus farm dwelling applications.
Okay, thank you, Mr. Pansky. Any questions on that? Okay, good, thank you. So I'll move on to item number 5, business arising from the previous meetings. Anything under that? Nothing? Okay, let's go to item 6.1. I have a motion by Councillor Basie, seconded by Councillor Bojan. That the report by Lisa Speakings, planning technician, dated May 21st, 2024, received in the bylaw 58 of 2024, deeming lot 11, plan 778, and lots 12 to 14, plan 25M to 23, not to be lots in a plan of subdivision, be approved by council and taken as having been read 3 times, finally passed, and the mayor and clerk be authorized to sign the said bylaw accordingly. Any questions on that? Hearing none, I'll call for the vote. All those in favor? Carried. Okay, council, let's go to item 6.2 of a motion by Councillor Van Claveren, seconded by Councillor Wolvett, that the report by Randy Burke, planner dated May the 15th, 2024, regarding 6749 Hummingbird Lane assumption be received, and that bylaw 61 of 2024 be approved by council and taking having been read 3 times and finally passed, and the mayor and clerk be authorized to sign the said bylaw accordingly. Any questions on that one? Councillor Wolvett and then Deputy Mayor.
I'm not sure who
Internet. You just explain this a little bit. Now, this gentleman is no longer with us, I believe, right?
You are correct.
Does he still have a company? Is that who we're agreeing with here?
I believe,
Or is this a private estate affair?
Ms. Burke, did you want to answer that one?
I do believe it still has
Okay.
control of the property.
I believe the estate has control of the property, Ms. Counselor.
Okay, so that, because it kind of mentioned, I forget the name of the.
So, and just so council is clear, we are only assuming the services. Under the development agreement, the services were put in, they're within the roadway, they become our services after two-year maintenance period lapses. Today, you're only accepting the services in the road allowance. The subdivision agreement still applies to the properties forevermore. So if there's provisions, which this one does have in regards to how the new home is built, graded, et cetera, those provisions do carry on, even though we are assuming the infrastructure today.
Thank you.
Deputy Mayor?
That was going to be my next question, because the development agreement, I think if I recall, it had a lot to do with the bushes at the perimeter.
Public? Can we attend?
You can come in.
No, thank you.
It's something to do with the bushes on the perimeter of the property, and now it's a wooden fence, and I just wondered if that was acceptable. But if we're not going into that agreement, and it's just the services, it doesn't need to even be answered. Thank you.
Your total package, Deputy. Any further? I'll call for the vote. All those in favor? Carried. Okay, item 7, bylaws. Anything under that? Deputy Clerk?
Nothing tonight.
Number 8, correspondence. Deputy Clerk, anything under that?
Well, we do have some recommended reading tonight.
Okay, so I'll take that to item number 9 then. I have a motion by Councillor Van Claver and seconded by Councillor Wolvette with the correspondence items A to F related to recommended reading and routine approval and information items not otherwise addressed by resolution be noted as received by the Plympton-Wyoming Council and filed accordingly. That's items A to F. Also, is there anything that you'd like to recognize or otherwise? Deputy Mayor?
Yeah, correspondence from Western Ontario Women's Caucus. I think we should support these letters. They're in a nutshell. They're asking the province at least appreciate agricultural lands a little instead of just chewing away at everything. So, and that's it in a nutshell. It's not quite their words, I understand, but I think we should support that. It's a great letter, and they're bringing attention to province about it.
And what item was that when they're
It's D.
E? Okay. You like to pull and support?
Yes.
Okay. Anything else? Councillor Rodriguez?
I think as well, they were mentioning about more funding for infrastructure,
Yes.
because I think
Is that in the same one, or what? There's 3 letters?
Yeah, and I'm not sure which one it's in, but I remember.
That's probably F, the development charges.
Yeah, this development.
I think we should support all 3. Yeah. E and F.
So D, E, and F?
Yes.
Deputy Mayor?
Yes.
Okay, Councillor Rodriguez says you have the floor. Is there, are you okay with those ones?
Yes. Oh, yep.
All.
Mhm.
Anything else? Am I right?
Looking to see if there's anything else down this way. Wasn't looking at you, madam.
I thought you wanted some.
Okay, I have a motion by Councillor Van Claveren, seconded by Councillor Wolvette, that the correspondence items A to F to recommend relating to recommended reading, routine approval and information items not otherwise addressed by resolution be noted as received by Plympton-Wyoming Council and filed accordingly, save and except for items D, E, and F. All those in favor? Carried. No, that's fine. That's fine. So Deputy Mayor, you're okay to make this motion? Councilor Rodriguez, are you okay to second it?
Videos also.
Okay, I have a motion by Deputy Mayor McCune, seconded by Councilor Rodriguez. The council supports correspondence items D, E, and F from the Western Ontario Wardens Caucus. ERO posting 019-8369, ERO posting 019-8462, and ERO posting 019-8371. All those in favor? Carried. Okay, let's go to item number 10. New business, beginning on my right. Councilor Bojan, anything under planning for new business for you?
Nothing for me, thank you.
Okay, Councilor Lazy.
Yes, just a quick, if we could remind our construction people, builders and road guys that it's their responsibility to keep the roads clean when it rains every other day. I know it's hard, but I was out on the bike the other day and it was hot everywhere, all over the place. That's all.
Thank you, Councilor Lazy. Although this is only a planning meeting, I'm sure Mr. Silva is making notes. We didn't want to get mud on those training wheels, so that's good. Councilor Rodriguez, anything from you? Deputy Mayor?
No.
Councilor Van Clyburn?
Nothing for me, sir.
Councilor Wolbeck? And under new business. So next on our agenda is a closed meeting session, but I would like to defer that until after our public meeting, because we have a couple of issues to discuss at that time. So at this time, I'm going to call for a brief recess. We'll be reconvening for 6 o'clock as we have a public meeting right then. So I would ask council to stay close by and be returned to your chairs by 5 to 6. So we'll take a brief recess. Okay, welcome back, council, and for those that are joining us virtually, thank you for returning. This is our special short-term rental licensing and planning public meeting. The zoning bylaw amendment 121 of 2023, official plan amendment 57. Monday, the 27th of May 2024. I would remind you that all our meetings are being broadcast and recorded. The recordings are going to be made available on the town's YouTube channel. I would remind council, if you have a pecuniary interest, to please declare it at the appropriate time. It's my pleasure this evening to introduce those that are taking part in our meeting. I'll begin on the right. We have Mr. Paul Da Silva, Director of Public Works, Corinne Nada, our Chief Building Official, Randy Burke, our planner, Councillor Alex Bojan, Councillor Mike Basie, Councillor Christian Rodriguez, our Deputy Clerk, Ella Flynn. To my left, I have Mr. Adam Sabansky, our Chief Administrative Officer, our Deputy Mayor Nettie McEwen, Mr. John Van Claveren, Sir Bob Wolvett. We have Mackenzie Baird, who's our upcoming planning technician, and Lisa Smeekins, our current planning technician. I have a motion by Councillor Basie, seconded by Councillor Bojan, that the report by Ella Flynn, Executive Assistant Deputy Clerk, Mr. Adam Sabansky, Chief Administrative Officer, dated May the 6th, 2024, regarding the short-term licensing bylaw and chronological timeline of STR discussions at council be received. Mr. Sabansky, I believe you'll be speaking to this.
Yes, sir. So as council is very much aware, we've been pushing this initiative through over a number of years, starting a little over 4 years ago when we first started to receive complaints. Staff have included a chronological order with links to those staff reports and agendas. So after much discussion, we've arrived today with 4 options. Obviously, we typically provide an option or a motion in the positive. So the motion that sits before you today matches our option 1, which is to accept the licensing bylaw as is. If you were to accept the licensing bylaw as is, we would then move into a OPA and ZBA public meeting to amend both of those documents to meet what we're approving today in the bylaw. You do a second option, which is at your hands tonight, is you could accept the licensing bylaw with minor amendments. Those minor amendments could not change the intent of the bylaw, as that would require the OPA ZBA amendments to be changed. And therefore we would not be able to carry on. However, only minor amendments are made, still carry on with the OPA and ZBA. Option 3 is you can again defer the bylaw. If you defer the bylaw tonight, obviously the OPA and ZBA meeting would be canceled, as there would be no short-term rental bylaw to consider. If you choose, given the amount of consultation leading to this point, if we choose today to defer the licensing bylaw in front of you, it has to be for specific reasons. So have staff have clear direction on what we need to bring back to you. I.e., if you wish to seek an alternative arrangement to the bylaw, seek additional legal advice outside previously provided advice to review other means that have not been included in this bylaw. Those are things that can create deferral because they will result in a major overhaul of the bylaw to meet the council as a whole direction. Option 4 obviously would be to defeat the licensing bylaw. If you defeat the licensing bylaw today, obviously we would not carry forward with the OPA ZBA. However, if you defeat the bylaw, you can defeat it in 2 ways. You can defeat it with no further direction, which would result in status quo being maintained until such time direction is provided, or you could defeat it and then provide direction to look into something such as a registration program or an alternative means of regulation if you so choose. Staff have also put together a brief information session. I was going to read out some of the stats from the overview. From 219 responses we had during the initial public consultation stages, 67% approximately believe that the STRs should be regulated. 24% believe that they should not. 65% of participants felt that they are that STRs are somewhat uncomfortable in their neighborhoods. 32% felt there was no issues. 56% felt that STRs negatively impact their property and values. 29%, or sorry, 30% felt there was no impacts. 11% felt that STRs positively impact their neighborhoods. Again, sorry, there's multiple lines in this one. So yeah, 29% felt they didn't impact, and then 11% felt that they improved property values. Regulations that were discussed is 63% felt that the number of occupants should be limited. 54% felt that there should be a limited number in certain neighborhoods. 51% felt that they should be inspected to ensure they meet regulations. And 50% felt there should be a limited number of licenses every year. Again, although we made every effort to gather as much information as we could from as many citizens, turnout was unfortunately low, and those specific results were only from 219 respondents. Lisa, if you don't mind putting up the open house results quickly. So planning staff carried out an open house on our behalf with a set grouping of questions. The first grouping in front of you today is what should be regulated, if anything. And you can see that most of the topics, the respondents were requesting some form of regulation. If we go on to the separate, it was more of a general question on the next slide that asked, should they be regulated, should not there be regulated, etc. One question was, should they be in place for the owner be in place for 2 years before they are regulated? A large number felt that it was very important. However, an almost corresponding amount of people felt that there was no point to that and were not in favor of it. In regards to regulations, it was asked whether or not regulations are important to the community. Again, you had very few in favor of no regulations. However, you said some who were in favor considered it not important, but the majority did consider it not in favor of most regulations. Through the research, we're also able to verify our numbers of current STRs listed in the town of Plympton-Wyoming. Grant, I guess, provided this information to us, who is a STR management company who manages programs on behalf of the municipalities. They were able to verify that there is 67 listings from 66 unique rental units scattered through Plympton-Wyoming, mostly concentrating along the lakefront area. Of that breakdown, they provided us a little bit of further breakdown on the next slide. They confirmed that the average listing cost was 195 USD a night. The typical unit type was 95% for the entire home and 5% for a partial home. So that 5% would make up typically your owner occupied because they're only rented out a partial home. Listing types, 92% were listed as single family homes, 2% were listed as multifamily homes, and 6% were unknown listings. Again, a lot of the information we gathered was limited due to the limited response. However, we wanted to share the previous information for you tonight to ensure that we all had it in hand as we further deliberate this bylaw.
Okay, thank you, Mr. Sabansky. So is there any further questions on that report before we receive it? Not to make a decision, just to receive the report. And hearing none, I'll call for the vote to receive the report. All those in favor? Okay, we have some correspondence that we have received in the last while relating to this report, and actually want to thank staff for updating us as soon as you got it. Some of it come in late. I'm hoping council has had a chance to review it on your own, and I thank you for that. I believe we have three people signed up to speak this evening, Ms. Meekins. I'm gonna go to Laura Markslag, who's, I hope, with us virtually. I'll just let you set that up, please. Okay, Laura, welcome. You are on if you have a few comments you'd like to make.
Okay, I'll turn my camera on there. Hi everyone. I actually didn't have anything in particular to say. I just wasn't able to make it to your meeting in time. So I'd like to say that thank you for including us in the meeting and this discussion. And I think it's very fruitful. And I continue to have really great guests that visit the cottage that I have when I'm not able to be there. There's nothing else I'd like to add at this point.
All right, thank you. Second, we have Alex Dimer, who's present. Alex, welcome.
Thank you. Thank you very much. I just have a couple of points that I'd like to bring up. When I reached out to Lisa asking, one question I had that really kind of bothered me a little bit. This process has been going on probably since 2020. Been participating in various formats, and I'd like to thank council for that. But the question I asked was, has anybody from council declared a conflict of interest at any point? And to date, what I was told is nobody has. And that shocked me a little bit when I understand there are some councillors who have family members who own Airbnbs. There are some councillors who participate in the real estate market who have partners or colleagues in the same business who are managing Airbnbs or other short-term rentals. And if you want to define what a conflict is, you know, family, friendships, financial or social factors that could compromise the judgment. I'm not saying that they are, but they could. But to date, to have nobody declare a conflict based on those, I find quite shocking. I'll just leave that as a statement for why that hasn't happened. That I'll leave for you guys to decide later on how you want to do that. Second, I think from day one, the definition of commercial activities has been demeaned. I mean, there are no commercial activities to be had in a residential area. Commercial activity says you're trying to make profit, you want money. We've now put the financial interest with the way the bylaw has been put forward to be more important than the rest of the community and how it's affecting the community. You are allowing these units to be zoned as hotels or motels. These are commercial activities. Collingwood, Toronto, Ottawa, all recognize that dwellings for under 28-day rentals, they're commercial activities and they're not supported. This was part of the OMB that said we will not recognize this. Even in the own reports that you've put forward back in December 4th, 2023, where you said, you know, there's 59 short-term rentals and only 6 are owner occupied, much like the data that was just shown here. These are commercial activities. These are investment activities. They're not about people trying to cover their own expenses for a couple days because things are got higher. If that was the case, you'd allow the bylaw to say, you know what, rent it for 2 weeks of the year. Right now, your bylaw is saying 365 days, make all the money you can. If you want to help them cover expenses, limit it. Why not just say in July and August, you can rent it out for a week? No one's renting on the lake from October through April, but you're allowing them to do all of this. Those are commercial activities. Lastly, I'd like to talk about the whole idea of owner-operated versus separate residence. Again, the data shows these are investment properties. They're not owner-operated. City of Sarnia said you have to be an owner-operated. St. Clair Township, they're saying owner-operated. At the open house events, the majority, even 67%, I think the data said, would like owner-operated. 66 communities in BC have now said no to Airbnb. New York, Collingwood is limited to 200 licenses. Blue Water Township, 15% on a street. Okay, no adjacent properties. You are just basically saying right now by this bylaw, anybody can have an Airbnb, a VRBO, a short-term rental. You saw the map. It's only a lakefront issue. So everybody who's in Wyoming here, it's not why did you get such low uptake? Everybody on the lake went to that meeting and said no. Everybody who's not on the lake, we don't care, right? You have to represent everything. And then I don't know if anything's going to change today, but the last question I have is, there's going to be costs here for us as taxpayers, as citizens. Why haven't you applied the 4% municipality accommodation tax such as available here? You know, somewhere townships have put 2, 3, 4%, but why are you going to incur these costs if you're going to push this through? This is commercial activity. Make the people who are going to use it pay. Thank you very much for the opportunity.
You're welcome. Thank you, Alex. The only thing I can share with you, as in every meeting, I ask if anybody has a conflict of interest. I can't tell them, neither can staff, that they do have a conflict. They have to be honest and answer on their own. So I can share that part with you.
Thank you.
Further that, each counselor at the beginning of the term has always provided training what constitutes a conflict of interest. And every counselor has access to the integrity commissioner to ask questions of the integrity commissioner to help them guide them through that process. On the same note, the community who feel that there could be conflict of interest also have access to the integrity commissioner for those purposes.
All right, our next speaker is Mr. Joe Kerrigan. Joe?
I didn't sign up to speak. I just submitted a document.
Sorry, I have it listed that you did one. You okay? Okay, council, let's go to item 4.4.1. Motion by Deputy Mayor McEwen, seconded by Councillor Vasey, that comments and presentations from members of the public be received in bylaw 116 of 2023, being a bylaw to license, regulate, and govern the operation of short-term rentals, taking as having been read 3 times, finally passed, and the mayor and clerk be authorized to sign the said bylaw accordingly. Now, council, this is the opportunity where we talk about it. Anything to my right?
Yeah. I wasn't sure if you were gonna call our names.
No, just to the right this time.
Okay.
Councilor Rodriguez?
So I do have 2 questions. One is on the insurance amount. So I'm just curious how we come to an amount for minimum insurance. The reason why I ask, I just want to know why. How does that number work? Because we don't have any vested interest in the property. The insurance company does. To me, I think it would be more better suited, and insurance amounts could be different based on the insurance company and what they would like to insure it for based on their risk and values and so forth. They're the experts, in my opinion. And shouldn't it be just providing a document stating that there is insurance coverage? Me, because nothing even speaks to that to show that they have insurance coverage for rental. And leave the amount to the experts. Does that make sense what I'm asking?
So, yes, may I?
Yes.
The $2 million was set based off of our previous experiences as well as recommendations made by our insurance company. The general rule of thumb for our insurance company, if an activity is low risk, i.e. on private property, on town property that is not a roadway and involves lower levels of risk, $2 million is your standard lower limit for liability insurance. Higher risk activities such as construction sites, road excavation, heavy construction tends to always have a $5 million liability limit at this time. So those are general rules of thumb that have been discussed with our insurance company and through staff experience. But no, they have not been set through any formal process.
Right, so I get what you're saying when you're talking about like insurance for doing construction, things like that. I get that. Because you're involved, right? They're working on your property. They need to prove and have a minimum standard. But in this case, this is okay, so for example, do we issue business licenses for commercial establishments?
Plympton-Wyoming does not issue business licenses.
So you don't also expect to receive or impose insurance standards on a commercial property, correct?
because we don't license them. However, in this situation, we are licensing them. We are carrying out inspections and other activities. If someone was to become injured on that on that property and the injured person submitted claim, in theory, they could submit a claim against the town for the negligence of our inspectors who didn't catch the error. And therefore, we do need to be protected by insurance because we are licensing them. If we weren't licensing them, then no, we would not need insurance. But because the town is involving themselves in the regulation of those buildings, and we are carrying out physical inspections, we do increase our liability. So if something were to go wrong, specifically that we inspected, they could bring a claim against us, and we would want that insurance not only protect the property owner, but protect us in turn.
Yeah, and I agree with what you're saying, if it would be applied to any other commercial, which is not, they're doing all the exact same things, but yet you're not looking at that.
Crystal, speak up, please.
Oh, I'm sorry. So all I'm worried about is we're inserting ourselves into something we're not an expert at on evaluation. I think the experts, which is the insurers of that property, should be the ones to determine, because it could actually be higher. They may want higher or lower. And what we should be asking for is proof of insurance that covers renters in the property, short-term renters in the property, because that's what insurance companies do, right? You have to get a different type of insurance when you're having renters. So I just, and nothing really states that you have to prove you have that proper insurance for rental.
Does it insure me next door?
So again, the $2 million was developed on the town's basic level of risk. Town is becoming involved. The town typically requires any property owner who we are becoming in risk with, whether through an easement agreement, such as what we do downtown Wyoming, or encroachment agreements, I should say. Our minimum requirement is always $2 million liability for low risk activities. So that's what was applied in this situation. The property owners insurance companies are not there to look after the town of Plympton-Wyoming. They are looking after themselves and those property owners. So we want to make sure that this bare minimum risk, the property owners insurance company may say, no, you just want 100,000. Because typically in the insurance industry, they'll sue up to the maximum amount and then look for others to the amount. So if they probably only had 100,000 and we licensed them and they felt it was a $2 million claim, they would come looking for the town of Plympton-Wyoming for that remaining 1,900,000. So this is simply to ensure that they have a larger liability premium to protect us in this situation.
You don't have the wording about. It's
Fair enough, but this has been worded from our insurance company, not theirs. Our insurance company is who we rely upon for risk, not theirs.
the wording that it's covering rental. Right, you could have $2 million liability or $5 million liability or 1 million.
It's not.
Doesn't mean it's covering, it doesn't mean you have the proper insurance.
Mhm.
You see what I'm saying?
But it's general liability insurance. It's not necessarily intended to cover the renter. They have to have rental insurance through their company to do that. This is liability insurance to cover general liability, which would help protect us in the case of a claim. So we're talking two things: renter's liability, which if the rentor is sued by the rentee, or vice versa, my apologies, where this $2 million blanket could be called upon to cover outside entities such as ourselves, the county of Lambton for doing building inspections, the town of Plympton-Wyoming's fire department for doing the fire inspections, etc. So they're not necessarily apples to apples, and $2 million is typically our minimum level for minimum to low risk activities.
Ms. Meekus, did you have a comment?
Your worship. I just wanted to know, I have the laws from the licensing bylaw up on there, and it does state that the proof of insurance has to identify that a short-term rental is being offered.
Okay,
on the
great,
premises.
thank you for that clarification, Lisa.
One of the things that I forgot to do, and I do apologize before I went to our council for questions. Is there anybody else in the public? I will I empower my office, offer anybody else that has a comment, the opportunity, they have 5 minutes. If there's anybody here that would like to speak, I know we've had presentations from Chu for sure, but if anybody else, you have an opportunity now. Okay, yes, John? You can go right ahead, sir. Just for the record, identify yourself, please.
My name is John Kreitzman. I live at 3714 Beverly Glen. And I've watched the proceedings here since 2020 when we did locate in this lovely place. And my observation is that in no situation should any adjoining neighbors or population or anything like that have to take on a group of people who arrive as guests or clients or whatever and try to elicit or extract good behavior from them to the point that it becomes a conflict. This is an unacceptable situation. No neighbor or person who lives in the neighborhood should have to feel threatened or challenged in a way that they couldn't deal with their fellow neighbor. In most neighborhoods, people get along. They work to get along. They make the things work properly between them. And parties and get-togethers are negotiated events, and they're wonderful. It's when you get a weekender crew has arrived for one reason only, to have a real good time and no consideration of anything else because they paid for that. And they're going to have their time. Plead and ask this council to consider that these situations should not arise. And it is by having some or other rule of law that would govern how things would go, things could get out of hand. That is my statement.
Good, thank you very much. Anybody else? Okay. I'll now go to Councillor Maisie. You have another one.
So,
Sorry, last I knew she wasn't.
the, speaking to what, Mr. Kriegsman has said, and I think it's in another one of our, letters we received, is there a minimum stay we could, add to that to?
Kristen,
Sorry,
we're back here.
sorry. Is there, I'm speaking to, is there what Mr. Kriegsman just spoke to and another letter we received, regarding minimum stays that maybe would alleviate some of these weekenders? Problems that come up. So I'm asking about like a minimum 5-day stay. Is that a possibility? Is what I'm asking. If we refer to the one letter from the Maduros, we mentioned that.
I'd have to seek legal advice on to what, if that is permissible or not. With most bylaws, municipalities can ask what they see fit, however, until they're challenged. So to confirm the legality or the risk with that clause being added to the bylaw, I would have to seek legal advice to be able to firmly answer for you.
Can I just add on to that, that wouldn't solve the problem anyway, because they would rent the place for 5 days and then just go party for 2 anyway. So, you know, wouldn't solve anything, putting that clause in.
Well, I just look at this property owner and they've showed that it, they've stated that it
Yes.
has reduced they haven't had any problems with it.
Any more questions, Councillor Rodriguez?
No. The fire inspections. Wait.
Well, the only comment I've got is I've been doing this for I think almost 4 years now. I've been back and forth on both sides of it. And when it comes down to me is we're looking to appease 60 people in our neighborhood or in our town. And it's affecting 10 times that. So to me, it makes no sense that we do nothing. If we turn this down, then the next motion would be to ban them outright and let the neighbors leave them be. Because the troublemakers that we're getting, we don't get anything out of it as a town. We're not getting tax money as stated. And it's affecting our residents that we said we would protect when we all ran for council, that we would deal with this. So if we don't put something in writing and get it moving forward, then we're letting everybody else down. So for 60 people, I will side with the other side saying either we put laws in place that we can take away the conflicts that are happening by having the bylaw officers deal with it, or we just ban them outright. Which is what Nettie put into place 3 years ago. She said this, I believe.
Well, nobody listens to me.
I'm listening now. That's where I stand. Thank you.
Councillor Bulgin?
Thank you. Yeah, just to build off Councillor Vasey there too, if my brain's been racking around how when you listen to the stats, it was a low turnout. So basically you've got, like any public consultation, you got your small pool of people who are passionate against it. You got your small pool of people who are passionately in favor of it. And you've got the rest of the people who we can only assume don't care as long as it doesn't impact their wallet. In other words, if we're going to license it, it shouldn't cost the taxpayers money. That type of mindset is what I assume is happening here. I think, to be frank, I think even if we pass this bylaw, I don't think it's going to be in place by July 1st. I know staff have in there that July 1st would be the go live date. I think even if council was happy with this, I don't think we're seeing this in place by July 1st. We would have to have the applicants put all their stuff together and apply, staff review it. So no matter what, I don't think this is going to be ready for this summer, which is unfortunate to begin with. I think with this decision, we're going to make some people happy. Some people are going to be mad. But right now, everybody's mad because we just haven't done anything. I mean, I wasn't here for when it started, but now I've been here for 1.5 years, 2 years, and we're still seemingly dragging our feet. So something needs to be done. I think Councillor Vasey is kind of on the same train of thought that I'm on. My biggest piece with what's presented tonight, which I think we'll have to discuss no matter what, is at the risk of being a broken record, where we were told that we had to do an official plan amendment and a zoning amendment because of the way the official plan was written. Because the previous council had put in details about a short-term rental registration program in the official plan. So instead of council having the ability to just make a licensing program, discuss it, consultation, pass it, we had to do a long drawn-out official plan amendment, which if we don't approve this tonight, we're going to restart the clock and have to do the OPA process again. So in my mind, no matter what decision we make tonight, I think we have to completely pull this out of the OPA, completely pull it out of the zoning bylaw, because in the official plan, there's a sentence, the first paragraph, I think, is where we can leave it, where it says something along, I can't find it right now, something along the lines of the municipality may license, restrict, or regulate short-term rentals. It's very vague. And in my mind, that's because that would then allow council to have a licensing program if we want it, without doing an OPA. So I think tonight, we'll still need to give direction if council is in favor of it, but we'll need to change our OPA no matter what, because right now we're trying to band-aid it with our OPA. And in my perspective, the OPA needs to be vague about short-term rentals, and then we can have the discussion. Do we want to do owner-occupied only? If now we have the freedom to do that, or even a license program if council still wants to go that route. But no matter what, we have to change our OPA. And in my perspective, we have to keep it vague. That's my biggest hurdle right now tonight, is what's in front of us is changing the OPA again by putting in the licensing program. So if 2 months from now, the licensing program is not working because we're hearing from the community again, we have to do an OPA amendment and start the process again to make changes. So I just think we need to scrap the OPA as the tool here and focus on a program that either restricts it or regulates it. And I hope that kind of makes sense, but that's the hurdle I can't get over right now, whether I want it to be owner occupied only or licensed. We're still not getting around this long drawn out process. We're going to be here again in a year and nobody's going to be happy. So I guess my question to staff is, can we pull that out of the OPA, keep the OPA vague, so we don't have to continually reopen the official plan?
Mr. Shabansky?
But actually look at her tonight, Ms. Burke, see if she has any comments to follow up that with.
So through your worship, I guess it will be council's decision of what they wanted the official plan to look like. As kind of it's written now, it is quite vague in comparison to what was there. What was there before required. It speaks of a site plan, a zoning bylaw amendment. What's in there now, though, is a reflection of the licensing bylaw that is presented tonight. So I guess with council's direction, it can be even vaguer than what is provided. But eventually down the line, it may be beneficial to put something just once maybe more put in place of what is going on with short-term rentals. It could be more beneficial to have just a little bit more guidance, so that way whenever issues come up, staff could go back and there may just be a little bit more there for when complaints come up or anything like that.
Councilor Bolger?
Yeah, and I understand that approach. Just trying to pull it, because it does, in the new amendments, it's very specific to specific lines in the bylaw. And again, the short-term rental world, like look how much things have changed. So let's just say we pass a license bylaw. There's very good reason we would have to change something. So we would have to go into the official plan again because there are things in here that are specific to lines in the bylaw. So I am just me personally of the mindset that the first paragraph is just the town may establish through zoning bylaw or a municipal licensing framework appropriate provisions related to the nature, scale, and density of short-term vacation rentals preamble. But then it goes into the very specific licensing bylaw. So I think if we just leave it as that first paragraph, OPA goes through its process, passes, OPA is done, and then council can more expediently say, okay, let's figure out what we want to do. If it's owner occupied only, perfect. Let's do a quick public meeting for council to hear from the public, vote on it, pass it. If it's a licensing program, same thing. Invite the public, pass it. Then we don't have to do a statutory OPA amendment every single time we want to change something. That's where I'm at.
Bolger? Vansky?
To clarify, Councillor Bojan's comments, what I'm hearing is that you would be leaning towards deferral to allow the OPA and ZBA to be amended to be more vague, to allow what bylaw is in front of you today to be easierly updated in coming months, days, years.
Well, to be honest, I wish we could just make a decision or vote on something tonight and see where the cards are on council. But that being said, even if we do that, we still have to change the OP. So no matter what, we're changing the OP. So I would just like to change the OP once and for all. Done with it when it comes to short-term rentals. We never have to reopen it again for short-term rentals. And that can happen, and simultaneously council can re-engage. If it defers tonight, we can do this while the OPA goes to bed for good when it comes to short-term rentals. And then council, if council wants to defer it for legal advice, if council wants to vote it down and then bring a new motion, like Councilor Vasey said, I don't know what direction we'll go after that, but no matter what, we have to change the official plan because it's baked into it right now.
So if the zoning bylaw, or sorry, if the licensing bylaw were passed tonight, you would then be suggesting that the OPA, ZBA be deferred to allow it to be more vague, to allow council further ability to amend the licensing bylaw in the future without the restrictions of the OPA being on it.
I would, yeah, because if council said this license program is not working, let's scrap it. We'd have to do official plan changes again.
And then planning and clerk's department, we can work through, if that's the direction of council, how to lessen the not accurateness, to make the bylaw and both the zoning bylaw and the official plan more vague to allow for more wiggle room with council's abilities with that licensing.
That it, Councilor Bolger?
That's everything for now, thank you.
Councilor Wolfett, anything from you?
Well, I'll make some comments. I mean, you know, going way back when this thing first started, I was the first person in council to bring this about a problem with a. I brought it to this council. And I remember some of the initial words I used was, let's not blow this thing all out of proportion. Let's deal with where we're having the problems, who we're having the problems with. And not get into a big complicated bylaw like we have here in front of us. This is a very complicated bylaw, a very expensive bylaw, which will cost taxpayers money, no matter what you look at. You look at this, You look at the time involved in what's being proposed here for inspections of these short-term rentals by fire chiefs, chief building inspectors, and so on and so forth. It's not going to be cheap. It's going to end with our staff. It's going to be very time consuming. We're certainly a small number of properties that we have complaints. At this point in time, and believe me, I've done an awful lot of thought around this thing. I tried to move in this council chambers a couple of months ago to get all these properties registered. Let's find out where they are, who the owners are, how we can get a hold of them, and get them registered. And that didn't happen. Now here we are, pretty near the beginning of the summer. And I agree with fellow Councilor Bojan. I have my doubts if anything's going to be done here by summertime. In 30 days. Yeah, it takes a long time to move it. I just want to point out that this bylaw, if this bylaw was being put to any of you people out there on your homes, or whether you decided to rent out your home, there's no way that you would have to meet the requirements of this bylaw. What's in here is unbelievable. Unbelievable. And for a small number of people, and the inspections and what they have to go through, and the licensing, which is very expensive, you're going to have a bylaw officer spending lots of time if there's any big issues. And I'm not sure there is, because I would kind of like to know, like this past May the 24th weekend, how many complaints did we receive from short-term rentals? How many have we received in the last year? Like, there's not big numbers here, a handful maybe. And I can tell you, I live out by the lake. And I can tell you that my street this past May the 24th weekend was full of cars, backyard fires, ATVs, boats, people having fun. People having fun. But none of them were short-term rentals. Would I want these rules and regulations around those people, including myself on that street? I don't think so.
How many people had fireworks on Tuesday at 1 a.m? How many people came
On
down
our street, they did.
How many people came down your stairs because the Airbnb two beside you wouldn't walk to the right of way? And you said, get off my property. And they said, I'm here for the weekend. It's worth you yelling at me.
And I can't answer to that, but there was lots of people on our street that come from.
That's every single time somebody rents.
In our community, they come from all over to use the beach. That is, by the way, the park to get onto that beach is private. So I'm not talking about myself. I'm just telling you what this bylaw is and what it isn't. Take a look at it, study it, and see if you would want these conditions put on your own property.
At $500 a night, it's not too bad.
Well, you have the option. Right now, the other thing I'm going to say here tonight is that the information we've got right from the beginning, especially legal advice and stuff, I don't think we've got the right information. When we started fighting for this, we were looking at no Airbnb in a residential neighborhood, because what you talked about, sir, about commercial. We failed. We were told you can't do that. You can't stop it. You can't stop it. If a farmer out there owns 3 or 4 cottages out in Blue Point, he can rent them out. We were told you can't. You can't stop it by legal. So the advice, we've been getting advice here at this council, believe me, like legal and everything else. And this is how we're trying to make our decisions here on what you see in front of you. I don't know what else to say, because it's very complicated. We've been told you can't put people out of business, including commercial. You can't stop commercial in residential neighborhoods, which I totally disagree with. I think you can. And some of the stuff I've heard tonight behind the scenes is that you probably can stop it. But once again, legal. We're listening to legal. Anyways, I don't know where this thing is going. But like I say, this is one complicated bylaw, very onerous to the town, very expensive to the town. It's going to cost money. And like I say, these people that do own these short-term rentals are going to have to put up with inspections by fire chiefs, building inspectors, probably even their septic will be inspected if they. So it is onerous, and I just think you have to ask yourselves, the property owners, would you want this kind of a bylaw put on you? And by the way, we do have bylaws that we can restrict lots of things that you're doing at your house. If you don't cut your grass or you don't do this, we have lots of bylaws. So, I just
no homeowner has to face this if there's no commercial activity.
Well, yeah, I can't disagree with you. I can't
We're
disagree.
we're trying to build commercial rules in residential homes.
But,
There's the problem.
but our advice here, as the rest of the counselors, but the advice that we've taken from legal is what we're presenting to you, and that is, we can't stop it.
I can't have a dump at my house. I can't open a retail spot at my house, but you can operate a hotel. Your advice is terrible. That you're
Well,
getting.
we not only can operate a hotel now, the new rules and regulations are, we can have 3 dwellings on our property, accessory buildings now, one in your basement, your house. Probably can put a little building in the back under the right rules and regulations. There could be 3 people on some of them properties up there.
Counselor, well, just to answer one of your questions, there was no complaints on the weekend.
No complaints in the weekend, so. And like I say, yes, on our street, there was lots of fireworks going off and there was no short-term rentals on that street. And that was Thursday night, not on the long weekend.
Thank you.
Thank you.
Counselor.
That's all I have. It's just comments. Complicated.
Counselor Van Claveren?
Thank you, Mr. Mayor. We have a few conflicts and maybe or comments rather. I would like to maybe speak real briefly. I don't feel I need to, but I think I'm out of respect to our distinguished guest, Mr. Deemer, in regards to a conflict. You're more than welcome to use my name. I'm the only realtor on council. And I have in no way, shape or form any business relationship with anybody in the short-term rental business. We might share a brokerage. We're all independent operators, so my conscience is crystal clear. In any one of these, in any neighborhood, there's multiple little enterprises. And just even driving through town here today, there's dog groomers, there's people groomers, there's long-term, almost nonstop garage sales happening at various properties. So there's lots of enterprises taking place throughout our municipality, and where does it start and where does it stop, and how much is in residential, how much is in commercial? A lot of folks are just trying to meet. Are there some making a lot of money? I have no doubt that there is. It's certainly not up to us to judge those particular folks because they're good with their money and they're entrepreneurial. Are they keeping the rules though? You sure want to make sure that peace are in every neighborhood. That's vital. That's for sure. But we don't want to snuff out somebody with a great idea that wants to make a few bucks and provide for their family. I don't see anything wrong with that whatsoever. Those are the folks that are also paying, in some cases, staff, employing people. They're looking after ball teams and buying jerseys and that. There's lots of opportunities for folks with good ideas, and they not necessarily always breaking the rules. Oftentimes they keep their properties looking better than the average might be. We want to discourage folks. We want to encourage them. And I think tonight I wasn't necessarily thinking along the lines of Councilors Bojan and Vasey, but I think they had some good points to simplify. I know right from the start, along with my counselor here to the left, keeping it simple was vital. And it really is morphed into something. And I've said it every time, and for the sake of harping on it, I think if we could register folks and being able to get a hold of them and that they have a certain set of criteria in place that isn't going to break their bank, and things are smooth, and then we respond to any complaints, then we certainly aim to do so. I appreciated very much all your letters, what you've said. I've taken them to heart, and they're polar opposites, as you can always imagine. And so that's probably all I have to say. I'm going to leave it there, Mr. Mayor. Thank you.
Thank you, Counselor. Deputy Mayor?
I'll try to make mine a little bit shorter. No offense. No, you either, Bob. Anyway, my first inclination is not to allow these STRs unless they are owner operated, owner occupied. It was suggested right from the beginning, but we were, in my recollection, we were told it was discriminatory. I think that's BS. I understand it's BS now. But anyway, so I really think if we just keep it simple and go to that, we don't have a lot of enforcement. And I hope we keep people happy that live next door, because the owner's sitting there listening to the noise that his occupants are making. So, and I know there's been a lot of work. Randy just left the room, but there's been a lot of work put into this bylaw, but I'm really not at ease with the enforcement issues. It's going to cost a whole bunch of bucks to try and enforce anything in that bylaw. Besides, when I read the bylaw, I didn't think it met the parking management plan didn't address any visitors that the people would have. They have to have a site plan of some sort, but if they have visitors, they're still going to park on the street. So
Leave any of the short-term rentals, unless any short-term rental that uses a platform, generally they do not allow visitors. You have to be a
No.
registered guest only,
okay,
but
Then
that doesn't mean people fall.
that's true. So anyway, I want to go back to the owner occupied, and I think it'll eliminate a lot of headaches. And also, like, if there's 76 units out there, houses out there, we're short housing. Why are we short housing? Well, 76 units could be available for people to buy or rent full time rather than short-term rentals. That would, loosen up 76 houses around our municipality for people that need housing. Province is dictating that anyway. All right. I'll keep it down to that.
Mr. Sabansky?
So there's just a few comments that I wanted to add to. Yes, the town did receive legal advice that we could not prohibit to owner occupied only due to the fact it would be discriminatory. We have seen numerous other municipalities enforce bylaws of that nature. So there could be an opportunity to look at this bylaw from an owner occupied area, seek complimentary legal advice on that matter. The bylaw is still open to amendment. Even if you were to pass it, it's open to amendment afterwards. Obviously, Councillor Bochin's comments would ring at that point, because if you chose to amend it after you approve it, it'd be much easier with the simplified zoning bylaw and official plan. So again, tonight, you have a number of options ahead of you. You can approve as is, you can approve as amended. Or if you want to take a reevaluation of the bylaw and look at alternatives, that obviously would be a notable change, and that would take time to come back. And that would result in a deferral today to come back with a much simplified bylaw. We'd likely have to break it back down and confirm whether tonight or another meeting, what areas council as a whole finds too restrictive, and then revisit those areas. Yes, we've done that in the past. Council as a whole left the bylaw in its form today, but if council as a whole feels that further limitations or reducing of the restrictions of the bylaw is needed, then you can defer it. Staff can bring it back. We can go through again line by line and eliminate what clauses you see are not fit. So deferral again is an option. And then of course, defeat. If you defeat the bylaw today, the bylaw in its current form is done. You can provide no direction. These will carry out through status quo and enforcing complaints as best as we can with our existing bylaws. Or if you defeat it, you can pass a motion directing staff to look at other avenues. So there is still options there.
Okay, does everybody understand the options that Mr. Sabansky has shared with us? Councilor Beasley?
Yes, it bugs me to no end that we defer this again and again, because we're here to make decisions. But I would like clarification on, can we restrict it to owner only? Because I know we were told we couldn't, but yet people around us are. And if we put forth that, you know, are we waiting for someone to challenge it in court to find out whether it's gonna stick? Or so. I guess I'm asking to defer until we get more legal.
Councilor Rodriguez?
Thank you. I have no problem with passing this tonight with some minor amendments. We were only recently told about the, owner occupied. Wasn't that not?
Legal advice was received early in the formation of the bylaw itself. However, the noticing of multiple municipalities around us and in other cottage heavy areas, passing owner occupied only bylaws has increased over the last.
Okay, so my concern with that is in our jurisdiction, we don't have any hotels or other type of occupancy, short-term, for people to stay at, with the exception of one little cute hotel at Reese's Corners. I do know with a lot of shutdowns, that happen throughout the years in the area, you know, quite often that overflow goes into our area. And as well as Lambton Shores area, when you get to bigger shutdowns. So people need short-term accommodations for work. They need it to come in for weddings or funeral, family reunions, all kinds of reasons. People need some sort of short-term accommodation. It is a fundamental part of any jurisdiction to have that. We don't have alternatives to that. So that's what makes us different than these adjoining jurisdictions. So that's a big concern. I don't think we have a shortage of housing by any sense of the word. We have 40 years worth of land to build on. We only have 6% that are owner occupied, which would have made this an entire waste of time. I believe that we should really just put something in place here. So that we have a registration, we have, you know, a licensing, you know, down the road, it's good, because if it does expand, we have to be able to amend it or keep it in check, whatever the case may be. So that's where my thoughts are.
Can I comment?
Mr. Dimers? Yes, you may.
So just with respect to that, when we talk about the need for hotels, we don't put hotels on city streets and town streets next to houses. That's why there are no hotels on the streets right now. You want to do that. This argument about shutdowns and we provide short-term housing. Great, make it minimum 28 days that they have to rent, because there's no shutdown that lasts for a weekend. People need, you want to put those, you're opening everything unlimited to the investor. You can rent whenever you want so that we can have a different person there for 52 weeks every single time. You have no barriers. Make it 30 days. And then we're probably all happy with that, because we'll build a relationship with those people. That's why we like the owner occupied stuff. There's a relationship. But when you give the opportunity for every weekend or every week, someone new to come in that we have to deal with, and there's no fight to anything, that's our problem, not your problem. You're just giving it to the investor. So I don't agree with any of those arguments you just made.
And I appreciate that. But there is a lot of bylaws that are already in place to deal with a lot of your complaints that that would be addressed even without that.
They can also go to Sarnia to a hotel.
Okay, council, we've, yes, ma'am.
I would just like to know who you think is voting for you? Who are you supposed to be representing? The people who live here or the investors that live in London and Toronto and Birmingham and the United States? And they have these short-term rentals and they don't care what happens to the people who live here, and neither do you if that's who you want to represent. Because that's who you're representing when you agree to this. Is people who don't even live here and don't vote for you. And I thought when I voted for people on this council, I really thought I was voting for somebody who was going to represent me. The person who lives here, not the people who live in other countries, other cities. But that's what you're doing.
Well, I live in an area where short-term rentals have been around for a long time, so I do know the problems with them. I also know of people who are just trying to hang on to their homes. You know, they're not trying to get rich. They live in this community. So I do know all the sides. Taking into account what our restrictions are here through legal, I'd like to see a bylaw passed that gives some accountability to these short-term renters to help reduce the problems that you're having, but also accommodates the people that do live in our community and do have these second homes, or people that want these investments so they can retire here. There's many reasons for these. We can't even limit it not being a corporation owned, which we asked if we could do that to stop these multi-property investors, but we're told we couldn't do that. So we're working with a set of limitations here.
You need to look a little deeper because other communities can look after the people who live.
That's what we were, so.
Yeah, please just have your name for the record. I'll have your name to include in the record.
Williams.
Okay, council. So I have a motion on the floor by Councillor McHugh and seconded by Councillor Basie. On this motion for the short-term rentals. From what I'm hearing and what I'm listening to, I believe that the first thing that I'm going to ask is for it, because of the comments that I'm receiving, is for a deferral. So this vote will be to defer it and bring it back with several of the options that have been brought up this evening. So all those in favor of, yes, Councillor Bud.
Can we clarify what the staff direction is for what they're bringing back?
Yes, we can.
I just, I put the email with their lawyer, so I think I would like to read the information they provided on discrimination before we proceed with the deferral, just so everyone's clear on what the lawyer has said we can and can't do based on what constitutes discrimination. So bylaws which operate unfairly and are partial and unequal in their operation between different classes are discriminatory and therefore illegal. A bylaw will not be characterized as discriminatory simply because it is directed at one particular person or lot. To be discriminatory, the bylaw must discriminate, give permission to one person and refuse permission to another, and must be carried out with an improper motive of favoring or hurting one individual without regard to the public interest.
Thank you, Ms. Flynn. Sorry, can you give me your question again? I was focusing on that.
I'm just wondering what we're specifically looking for in terms of information, if we're getting advice from other legal, or what we're talking about, like what we're asking for by deferring is what I'm just looking for clarification for before the vote.
Yes, because if we defer it, I need specific direction on what the activity is going to be when we leave here tonight. Is it to seek alternative legal advice in regards to the whole thing, to seek alternative legal advice in regards to the owner occupied only?
Based on the definition of discriminatory, though, I believe owner occupied would more than likely fall as discriminatory.
The challenge is who's going to take the municipalities to task on that.
Fine, it's very weird to me that we're talking about legal when the Municipal Act says legal advice is for closed session. I just want to make that clear. The second one, I think, if we followed that to the T, how can you discriminate against why you can have a gravel pit here, but you can't have, like, everything is discriminatory if you want to read it word by word.
Yep.
Like, why can I have this commercial two, but I can have commercial one next door? Like, all of that, if you read to the letter, is discriminatory. So again, I want to be clear that I find it very strange that we're talking about legal advice in public session, because municipal act is very clear that legal advice can be reserved for closed session, because this feels like a very weird thing to be talking about right now. But that definition, I mean, could be applied to literally everything.
The challenge I'm seeing with the deferral is I don't think council, from my observation, is unified on a reason to defer. We have a group who would like to see owner occupied only. We have groups that would like further legal definitions carried out. So I think deferral is a challenge at this point because there's no true direction to carry this forward through a deferral. Both will take the bylaw in a much different direction, which could then be, if it was defeated, we could be directed to take that bylaw in direction. So although I don't think a deferral works, given we don't have clear, concise direction to follow up deferral at this time.
So a defeated motion, if I'm correct, then will give you more direction of where you want to go.
You
Or
can
the
defeat it.
council wants you to go with it.
You could defeat it in two ways if you choose to. If you call the vote and it's defeated, you can not bring a follow-up motion to the floor, which would mean that we go to status quo until council directs otherwise. You could also defeat it, and then someone could put a motion on the floor to direct staff to work with legal counsel to consider owner occupied. And you could call a vote on it. Or if it passed, we move forward with the OPA, and then we discuss how to adjust the OPA within our abilities to do so to better accommodate council's future goals for the short-term rental.
I think we've worked long and hard to get to where we're at, and I don't want to personally drop. I think we either gotta move forward with this. We've been talking about it for a long period of time, so I think we need to forward. I have Deputy Mayor and Councillor Basu. You're the mover and the seconder. What would you guys look?
I already said, I just signed the motion to put it on the floor, which is a very unusual thing, which I didn't like to do, but I did. So I would like to see us put in a bylaw for owner occupied only. Okay, if we need legal advice, fine. I don't think we do. There's enough municipalities out there.
And we should have put the legal advice discussion to bed earlier. If the preference is to go to an owner occupied system only, that is quite a bit different than what you have in your hands. So I would suggest that you defeat this bylaw and then pass the second motion that staff bring back an alternative bylaw look or a report looking at an owner occupied only bylaw.
Mr. Basu?
But if we defeat this tonight and then the owner occupied doesn't go, we've spent 3 years of nothing and we still come out with nothing.
Yes, sir.
And we still have people wanting something that needs something to protect them. If we put this in, at least we have some groundwork that we can work with. I like your OPA to dumb it down so that we can work within ourselves and not have to go to all these other BS things. So the way it stands right now, I'm looking to at least get something in place, and then if we can adjust it to go to owner occupied through that, we can still do it through this.
And just because you pass this bylaw today does not mean you can't amend it, pull it, reassign it in the future.
Problem passing this bylaw the way it is, number one, you won't amend it. You're gonna leave 76 bed and breakfast or Airbnbs open and going against everything that these people are asking us to do to eliminate it. Commercial establishments in their neighborhood. All we're doing here is agreeing on, yeah, okay, you can have them anywhere you want. That's what this bylaw says. So if you pass that licensing is not gonna get changed. It's gonna stay the way it is. So you gotta make a decision here whether you're gonna have owner occupied or you're gonna go with 76 Airbnbs and bylaw officers. That's the only two options you have here. Well, you go with Nettie, I mean, we've been given some information here legally on can't do this owner occupied thing, but it sounds like maybe not the
Can we
case.
avoid further discussion on the legal matter, please?
Well, we can, but it's already been said, so.
Try not to discuss.
Counselor Vacy?
I understand that, but if we defeat this right now, it stays status quo, which is do nothing. So we still have 76 Airbnbs out there, and now we have no teeth to even go after them, is what this whole thing was about. So we could set fines, we could send the bylaw officer, he's got some, right now we send the OPP, they show up 4 days later for a noise complaint, the guy's gone, you're still in your backyard being threatened to whatever. We have nothing, so that's the only way I'm leaning. I would prefer owner occupied. Not allowed to do that, but we could mold this into that, could we not?
If we pass it tonight.
If we pass it tonight, we can still change it down the road. If we defeat it tonight, we have nothing. We can come back with the owner occupied if everyone's agreeing that's what we're gonna do, because I don't want to defeat this and then get left holding the bag empty. And now everybody's mad at us. It's the only reason I would consider defeating this.
There's timers.
So understand your logic there. What I've heard tonight is that it'd be expensive to manage these bylaws. You're gonna have to have all these inspectors doing work for a possibly temporary period that you don't think you can get a bylaw in for July 1. So you're gonna needlessly spend money on something you're potentially going to change versus agreeing now to defeat it and possibly then bring in an owner occupied bylaw, which won't cost you the same amount of money to manage and keep the citizens who are basically saying we're much happier with that. I don't think this is a decision at all. The no-brainer is you defeat it and you work in the next 30 days to bring the owner occupied there, and it will also limit the expense for council. That's the way I understand what I've heard tonight.
Mr. Bolton?
Thank you, Your Worship. My only caution too is no matter where individual councilors are on this, if the logic is passing this as presented with the idea of making amendments, we're essentially saying we're good with short-term rentals. So theoretically, Joe or Jane can buy a property tomorrow because we just passed a program that says you can do it. And then 30 days later, we pull the rug out of them. We gotta be transparent here of what council's intentions are. For the sake of the investors, people who want to buy real estate, people who are currently operating short-term rentals, in my opinion, we need to be transparent here. Instead of passing a bylaw and then changing the entire thing, because this bylaw says you can do it, and then if we want to do owner occupied, that means we flip the script on it, and now 66 or whatever the people who are operating are on the other side of it, even though we passed a bylaw. That's where I'm at.
So, thank you, Councilor Bojan, for quite correctly. Council as a whole feels that owner occupied is the better way to go, then you should probably defeat this. If council on a whole feels that regulating as per proposal or with small amendments, then the bylaw should be carried. If you defeat it, then you wanted the owner occupied only, then a follow-up motion would be helpful, so we have direction on where to take the next steps.
Just if we defeat this the way it is written, and we don't get the owner occupied because our lawyers say we can't do it, then now we start completely over from scratch. That's my fear. At least if we put this through, I'm looking at it as we start to get them registered. They start to pay fees, which will cover the costs. They have to pay for their own inspections. I would have preferred, like say, from day one, as I mentioned, the owner occupied. because we talked about that 3 years ago. We had a presentation by the lady here that is an owner occupied. I just don't want us leaving empty-handed with an empty bag of nothing. And leave you guys with nothing except the existing bylaws, which have proven they don't work because that's why you're all here. So that was the reasoning for the deferral, so that we didn't lose, at least have some kind of governing body that if we have to have these things in our town, that we can say how we have the law, we have something that we can find the people, we can constrict them, we can have something there.
Councilor Rodriguez, thank you, Councilor Vacy.
I think, well, can we defer based on this question? Till we, so we can get some clarification? So we'll at least know within the next month if we send it for clarification, you know, and then we know which way we need to go. I mean, because we've based this based on the legal direction we've been given. If we're questioning that legal direction now for some reason, then it should go back to legal to get clarification. And that way we know for sure which way to go.
Deputy Mayor?
If we defeat this and have another, can we not, how does the official plan and zoning bylaw, how are they affected? Or by, if we put in a bylaw to have only owner occupied?
We would have to come forward with a
Another,
different,
okay, it's not allowed under the OP the way it is,
No.
okay.
so the only way that there's any hope of getting this in place for this summer is to approve it as is tonight. If we're looking at owner occupied, we would have to go back, seek legal advice, bring that legal advice back to council. And then we'd have to create a bylaw based on council's direction from that meeting. In association with that bylaw, planning would have to go back and write another official plan amendment and zoning bylaw. Those amendments require 20 days notice, if I'm not mistaken. So the earliest you would be back would be August with a follow-up, whether that is the exact same similar bylaw to what you see today because the advice was created, or a owner occupied bylaw, which means that we would not encompass any of this cottage season by the time everything went through and was approved.
Councilor Bolger?
Thank you, Your Worship. Yeah, and just for clarification too, that's why my recommendation for council here is to consider separating these two issues. No matter what, the OP needs to change. So if we separate these two issues, staff can take that away if we direct them to make the OP more vague, so that no matter what we decide to do with short-term rentals, we don't need to do the OPA again. So my recommendation for council consideration is to separate the two. OPA gets changed so that it's vague enough that no matter what direction we go, we don't need to do it again. And I think the zoning bylaw can stay the same, because when I was looking through the changes, I think we were just adding things about short-term rentals. So I think the zoning can just stay the same. I don't think there's anything in our existing zoning that talks about short-term rentals specifically. So zoning can stay the same, and then we can just specify or de-specify, that's not a word, make the OPA more vague in this amendment, and then that goes away.
Then what about our bylaw?
Then we can,
Oh, but we have to wait until our OPA is in place.
once the OPA, no matter what, that clock starts ticking, because we have to change it no matter what, if we don't approve this as is. So let's just start that clock as soon as we can by changing it to be more vague. And then council, if we defer, if we, whatever the heck we do, at least we know that the OP's thing is getting resolved, and we don't need to reopen that, in my opinion.
So what you're saying then is that you would be suggesting that we defer it? No, you defeat it.
Carry the OPA.
My main recommendation is the OPA.
That's the hold up.
Well, no matter what, it's gotta be changed, because right now we've got half-baked restrictions in the OP that don't do anything. So we'd have to change the official plan no matter what. So I'm just saying, let's change the official plan and use one amendment that says the boilerplate, there's the first paragraph is a boilerplate that we can or might or might not make restrictions is what it says basically. And leave it at that for the official plan. And then if council wants to go above and beyond the official plan and introduce a licensing framework like it says we can, or we're occupied, no matter which direction we go at that point, the official plan stays the same.
Councilor Vacy?
Well, just to be clear, that if this goes through and it starts June first or July first, whatever the date is, the fines aren't gonna come into effect till next year anyway. It all has to go to court and Ottawa and the province. Everything has to- So it's got no teeth this year anyway. So
Useless. Why even?
basically, well, because if not, then we're gonna do it again next year and it's gonna be a year after that,
More sensible one next year.
hopefully. Well, that's what we thought we were starting out with. But all I'm saying is, if we delay this and get the proper information,
Versus starting.
you know what I'm saying? Like the finding thing is a year away, that it's, we're not gonna make any money off finding them anyway. So,
Okay, so trying to summarize the discussion. I'm hearing that the bylaw, the short-term rental bylaw itself, that the majority of councillors would like it to see deferred to seek further legal advice on whether or not they can go the direction of owner occupied only. But council may want to see the official plan move forward if it can be amended tonight to be more simple. Ms. Burke, given what you have in the official plan amendment today, does the Planning Act allow us to amend it here today? Or we have to come back with an amended OPA at a later date?
Through your worship. I'm not sure of the Planning Act, but I would recommend going through deferring the OPA, and that way it can be better crafted to fully encompass what council wants in terms of it being vague enough while still highlighting, short-term rentals as a use in the town, rather than like trying to craft it now.
So if we defer the licensing bylaw, we defer the OPA. The zoning bylaw mostly is definitions in it to allow to group itself with what council is directing to. And definitions likely should remain to exist if the OPA and the licensing bylaw is amended. Randy, do we have the opportunity to pass the zoning bylaw today? Or would you recommend deferring that as well and taking it back as a group in a future meeting?
I would recommend deferring it as well, because I do have something in there about parking spaces as well as where short-term rentals are permitted within the town. But it could come back in terms of a vague, so that way there are definitions in the zoning bylaw that can be referred to without kind of going into any special provisions specifically.
So what I'm hearing is, as a group, you seem to be leaning now towards more deferral of all three of those things. So if you defer the licensing bylaw will be with direction to seek alternative legal advice in regards to the ability to implement a owner occupied only short-term rental bylaw. Which because it is legal advice, that legal advice, I'm sorry for the public, would have to be heard in closed session. That is under the municipal act, as Councillor Bojan pointed out. From that meeting, we would receive direction whether or not to proceed with the bylaw as you see it here today, with or without amendments, or to turn direction and move towards a owner occupied system only. And then that would determine when we would come back with whatever bylaw we've been directed to develop and the accompanying zoning bylaw and official plan. That's what, if we were to defer today to further investigate owner occupied short-term rentals, that is what we would move through today. If the motion to defer is defeated, then council would have to either vote on defeating this bylaw as a whole or carrying the bylaw as a whole. Carried it as a whole, then the official plan and the zoning bylaw could be carried forward, or you could defer each to make them more vague as well. Like we've.
So just through your worship, and I'm not sure if this is what Mr. Nancy was getting at. But the official plan amendment, if it is vague, I don't believe it would need to wait specifically for a new bylaw to come. I do think we could probably get notice out and if that's what council wishes, to bring it forward sooner, if it is a vague one and not referencing specifically any form of a licensing program or anything like that. I do believe that's something, especially the official plan amendment, in terms of the zoning bylaw amendment, it could be looked at, but if that was to be a bit more specific, it should wait until there is a program in place. But the OPA, I'm in agreement with.
Very. So I hear what is on the table is the deferral to further investigate owner occupied, which would defer the whole process until we can provide that legal advice and then obtain direction from that legal advice. If that fails, then we would look to either carry or defeat what is in front of you today.
Okay.
Everybody clear on that, Deputy?
Yeah, you said that this couldn't be done till August sometime. I don't see anything wrong with getting this done by the end of next month. I'm sorry, I know that, yeah, I know, but
You would be then hearing a planning matter outside of planning,
what, the end of the
because
month?
I wouldn't have legal, because it would take me a few weeks to get legal advice.
A few weeks.
I don't want to commit to a timeline if I cannot deliver on it.
No.
So in theory, if you keep planning and planning, which has been the direction of council in the past, you would receive that legal advice at the end of June. Which then from that direction, we would develop something which we should be able to provide you at the end of July. However, bearing in mind that we do have a lot of other planning applications and other matters, so there's already tight timelines coming forward. So theoretically, we could get it in place at the end of July, which would then push the implementation into August.
Mr. Meekins?
I will note, based on planning app timelines, for an official plan amendment, notice requirement is 20 days before the meeting. Since this is something that applies to the entire municipality, it has to be notified through a public newspaper. So notice would have to be in the newspaper this Wednesday. So that means notice would have to go to the newspaper tomorrow morning, and they would have to accept that if we were to hear an official plan amendment next month. So that might not be feasible because the newspaper would already have its.
I thought 20 days.
That may only get us ahead with the official plan amendment. It would not help us get ahead with the actual licensing bylaw or owner occupied bylaw or the zoning amendments either. So we'd still be pushing those
Doesn't
timelines.
she have a cot in her office?
Well, actually, Deputy, I was with the editor before I got here, and she will be watching this, so I'm sure possibly she would save room for us. Won't you, Heather?
But again, if we're waiting for the licensing program, whichever form it takes in, the zoning bylaw anyways, is there a point of rushing the OPA ahead of time?
Yeah.
Or again, bring them all back at the same time in one concise, clear-ish meeting?
Concise and clear?
This is just a question through you, Mr. Mayor, but and this may be a useless exercise. I'm not sure. I'm just asking the question. But regardless, could we proceed with registration, move that along on the side? So that let's find out who's out there that's got these Airbnbs. Let's find out, let's get names. Let's find out if we have to send the bylaw officer to whatever. Well, all this other stuff is going on that we know where they're at, who owns them, phone numbers are. Can that be done by a separate motion?
It can be done through a separate motion, but as per our previous staff report, it doesn't actually buy us any time. We know where they're at through Airbnb, Verbo, and all. Most of those companies provide emergency contact numbers that residents can call if there's an issue, or the town can call if there's an issue, and then they can get a hold of the property owners. And if it's a licensing bylaw, it would still be the end of June before we bring it back. And then implementation, and the challenges that we ran into with a lot of our bylaws, unless your bylaw has set fines, it's enforced through the court system. So it starts out with laying orders. If those orders are ignored, then a court order, and then you go to the courts, and then 3 years later, you may see something occur. So that is why our staff did not encourage a registration bylaw in the first place, because we felt it did not address council as a whole's desire to provide some sort of ability for the residents to have their concerns addressed in a timely fashion, because the registration bylaw would not provide us that forceful mechanism to encourage compliance. It would just be us sending nastily worded letters that we would have to approach the court system to enforce, which unfortunately takes years and money through lawyers.
Okay, council, I think it's that time where we have, I'll reread the motion again. Moved by Deputy Mayor McEwen, seconded by Councillor Vaizey, that comments and presentation from members of the public be received, and that bylaw 116/2023 being a bylaw to license, regulate, and maintain operation of short-term rentals, taking as having been read 3 times and finally passed, and the mayor and clerk be authorized to sign the said bylaw accordingly. From what I'm hearing, excuse me, this motion will be to defer that motion.
To seek legal advice in regards to owner occupied.
So maybe we should just have that road in there as well, Ellen, please. Mover and the seconder, okay with that? Add to it.
Whole section of it.
The direction in your minutes will be clear that it's being deferred for me to seek legal advice. So I don't think you necessarily need to amend it. I think just if you deferred it, our direction is clear to seek that legal advice in regards to the ability to implement owner occupied only.
I think it probably wouldn't hurt.
That would be a different.
30th.
I'm gonna have to go back to my clerk on this one because
I would like to see that on that motion. To have it deferred until we receive.
For a reason why we do defer it.
If I may, the motion can also be defeated and reconsidered at a later date as per procedural bylaw. So that might be cleaner if this motion is defeated and a new motion be passed, that staff investigate the possibility of only licensing owner occupied short-term rentals.
if we did that to reconsider this bylaw in its current form, you would need the motion, the mover and seconder to support the reconsideration, and then I believe 2/3 of council.
I'm not sure I understand. We don't have to start a process all over again.
No. This
Okay.
exact motion could be reconsidered if it was defeated. I just think it might be cleaner instead of amending this motion to
And
defeat it and
If you
pass.
just, if you're deferring the motion, council's direction is clear. I think we can leave it out. I know the deputy mayor has concern in that, but the reporting and the minutes will be clear. And I think you could actually add into the minutes, because it's a little bit above and beyond, that the motion was deferred to allow staff to seek legal advice in regards to owner occupied only short-term rental regulations.
Okay, we reiterate now. It sounds like we're passing.
You're deferring it.
We're deferred if we.
Okay,
Ms. Meekins?
I will note that the motion starts with that comments and presentations from member of the public be received. Should that be separated into a separate motion? Because right now it's when we are receiving the public comments. And then pass it, like do it as 2 separate motions, so that the deferral's just on the bylaw, so that we did officially receive the public comments.
You can always receive them.
Technically a statutory public meeting.
That is true.
It was the OPA meeting, that would be more problematic, but this is not technically statutory.
Okay.
The cleanest way is just to outright defer it, and then council's directions stand.
We do have it not only recorded virtually, but everybody here is aware. We all should remember.
And they're gonna give us the record list heck when we see her.
Clerk will be probably monitoring it now. All right, council, I'm gonna call for the vote to be deferred.
to be deferred,
To
right?
be Deferred.
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 Okay.
Councilor Vaizey?
I'm voting, sorry.
All those in favor of deferral? Okay. So I go to item 6.1, that's the public meeting be adjourned. Do I have Moved by Councilor Rodriguez, seconded by Councilor Bojan, that the public meeting be deferred. All those in favor? Carried. All right. Thank you, everybody, for coming this evening. We are going to be taking a 10-minute recess, and then we'll be going back into a closed session. I thank each and every one of you for taking the time to be here. We appreciate it very much. Thank you. Okay, I have a motion by Counselor Bogan, second by Counselor Jason. The council moving the main camera meeting council. Pursuant to section 239 of the Municipal Act 2001 is amended for the following reasons. Item A, litigation matters, section 239 bracket 2. Bracket E, litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board. Item B, personal matters, section 239 bracket 2 bracket B. Personal matters about an identifiable individual, including municipal, local board employees. All those in favor? Carried.